My name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and we have a primary goal when we do these videos. And the primary goal is to make sure that the people who watch these videos, the people who may well be our clients, are better educated and know more about it than the other guys. Because if you do, come time for court, you're at a very, very distinct advantage. So subscribe to our channel to get information on topics that are of interest in general or specifically of interest to you. Now, we had a question from our viewing audience. When will a judge modify child support? It's a good question. I mean, just because you can ask for modification doesn't mean A, you should, and B, that the judge will grant it. Generally speaking, the judge is going to grant a change in support if there's been some significant change in circumstances. Maybe you were calculating the support based on a salary that is no longer realistic for you. Maybe you used to make $50,000, but because of cutbacks, you don't have that job, or now you've been cut back and you're only making 30. Or maybe the other side, the support was based on them being unemployed, and now mom is working and making a good salary. So if these numbers are no longer realistic, then the circumstances have changed. And if the circumstances have changed, then it's appropriate that the judge look at the whole thing, make a judgment, modify support to reflect the reality. I mean, that's the way it should be. I'll give you another example of reflecting that reality. Many times, child support, which will be based on the income, will also be based on the overnights. Mom is having a certain amount of overnights per week. Dad is having a certain amount of overnights per week. And so therefore, they have it worked out. Let's say 3 overnights for mom, 4 overnights for dad, and then the next week they flip it. And then when you do that, as the year goes, it's pretty darn even, because it's 3, 4, 4, 3, constantly flipping back and forth. The problem is when you have it set up in the order for 3, 4, 4, 3, so basically an alternating of the nights, but mom all of a sudden, she's not available to take her nights. So while she's getting credit in the support number for having the child pretty much half the time, she only actually takes the child 20% of the time. If that's the case, and you can show that that's been the history for, let's say, several months, in other words, it's not just a one-shot thing, it's been going on chronically, then that's a change in circumstances. The court should look at that change and make a modification. Now, I want you to be aware of one very important thing. Before you start to make a process where you ask the court to evaluate a change in circumstances and lower the support, you have to look at what the support was before to make sure that that support number was the appropriate number. You see, I've had cases where you have one person who is getting a certain amount of support, the other person's paying a certain amount of support, but the amount that they were paying was a number that they agreed to, which was dramatically lower than what it should have been. They're agreeing to, $100 a month. And now they want their support, reevaluated. And I've had people call me up and saying, I don't understand. I was paying $100 a month. I felt it was too much, and she was, spending the money on her hair and nails anyway, so the child wasn't getting it. I filed a motion to get it lowered, and not only didn't get lowered, now I got to pay $500 a month. Well, the answer is very clearly, the court looks at guidelines. And the court's going to employ the guidelines based on how much you make, how much she makes, how many overnights, and that's the formula. If you've had an unrealistically low number all along, you might be better off just leaving it at that number than asking for a reduction because you lost some income or something, or because you want the reduction. Because the fact of the matter is, once they reevaluate, they're going to look at the numbers all over again and replug them in. And when they do that, you need to be assured that the number you'll get will be a more favorable number than the one you already have. And if you're not 100% sure of that, you better not file that motion. If you want to get some insight into that, you're concerned about your calculation, or you want some help, reach out, and of course, we'll be glad to help you out.